It's a good day for Canadian air passenger travelers on a couple of different fronts. Yes, this idea of compensation, which we will get to in just a minute, but the story you may have missed. Canada's Competition Bureau has obtained court orders requiring Air Canada and WestJet to hand over information for their market study into airline competition, something that apparently they were not in a big hurry to do. Anthony Durocher is Deputy Commissioner at the Federal Competition Promotion Branch and on the line. Mr. Durocher, thanks for being here this afternoon.
My pleasure, Aaron.
Let me begin with this story. Again, I don't think most people were aware of this. Obviously, this is something you're involved in. How exactly does this work, and what does this ruling by the Competition Bureau actually mean?
Well, so this is in the context of a market study that the Competition Bureau launched this summer into the airline sector in Canada. And really the point of the market study is to assess how competition is working or isn't working well enough and what steps we can do to improve it. And as part of this market study, it's really important that we get, some of the critical information to enable us to properly assess what's going on with competition, what's working, what isn't. And obviously, Air Canada and WestJet are the two largest airlines in Canada, so their information was particularly important. So we got a court order basically requiring them to produce to us certain information that we've deemed important for this. It includes things like their own internal analyses of competition and competitors, some key performance metrics, a lot of their internal analyses, but really important for us to have this information to make informed findings and recommendations down the road.
To which I would ask, when I saw they're now compelled to do this, they were resisting doing this from the get-go?
Well, they have participated in our market study thus far, and there was a public consultation period where they provided submissions, and they're available on our website. But really, this for us is about getting the information that we need, all of it, and on a timely basis. So we have timelines for this market study where we're committed to producing a final report with recommendations in June. And working back from that, we need the critical information. And this is what this was about, was ensuring that, at least for Canada's two major airlines, we have all the information we need on a timely basis to really get a better understanding of how they view competition in the industry and so that we can assess how we can improve it.
Yeah, I mean, I get all that. I guess my question is, why did we need a court order to get this?
Well, experience has shown that these are very important tools to make sure that we get the information we need. So just take a step back. We did a similar market study in the grocery sector a couple of years ago. And we did not get all the information we needed from some of Canada's major grocers. And that actually prompted the Parliament of Canada to amend the Competition Act to give us the power to go to court to compel the provision of information. So this is actually a new tool that we have. So these amendments came into force in December of last year, so just a few months ago. And so we're putting them to use here. And experience has shown that these are very important tools, and a lot of competition agencies in other countries already have these tools and use them.
Okay. Yeah, again, I understand people have trade secrets, and it's a competitive business. I would see that, but obviously this is being not done privately. This is being done for the Competition Bureau, which is a good thing. So it's kind of surprising to hear that airlines wouldn't be forthcoming necessarily in offering up what you needed, but at least it's done, so I guess that's a good thing.
Yeah, and
okay.
From our perspective, we're all about understanding the competition issues and making recommendations on how we can improve competition in the sector, and that's important and good news for Canadians because competition is means lower prices, more choice, more innovation.
Yeah, in a perfect world. Anthony Durocher at the Federal Competition Promotion Branch. Thanks so much for the time.
My pleasure.
The other big story today, as far as, and this is kind of hitting a little closer to home because it concerns you if you've ever been in a situation traveling with one of our Canadian airlines where, I don't know, your luggage has been damaged, lost, your flight's been delayed, and you try to get money because apparently you're supposed to be able to. Well, today, as I said, Jason mentioned this off the top, the good news there is, Canadian Airlines failed in their challenge of the air passenger protection rules that the federal government implemented 5 years ago, John Gradek's a faculty lecturer at Operations and Integrated Aviation Management at McGill. He's on the line. John, we talked about this in the past and wondered how come, these rules are in place, but nothing ever seems to happen. So what does today's ruling actually mean?
Well, there's no more excuses for the airline not to be able to pay you compensation that is fairly owed to you as per the regulations. So, the airlines have been attempting to kind of, shuffle their feet in terms of paying you compensation that is due as per the regulations,
right,
in the hope that, these types of court appeals would in fact strike down the regulations. They've run out of leg room. There's no more appeals in the legal process, and now they have to start paying.
So, the question every time we talk about something like this from me to you is always this. In theory, this is a big win, or it sounds like a big win. In practice, you getting your money anytime faster?
No, of course not. But, at least your case is there to somehow, some way, wave the flag in front of the judiciary, whether it's small claims court or whether it's a CTA, to say, hey, these guys are kind of slow in paying, and they really haven't got any grounds that, say that they shouldn't be paying us. So please, exert whatever you have to do, judiciary, to get these guys to pay. And the other thing is that the CTA has been kind of reluctant. The Canadian Transportation Agency has been kind of reluctant to pay or to issue fines to these carriers for not for not paying.
Right.
I think the biggest fine they've charged is about $250. They have the power to go up to $250,000 for every occurrence. So I think what we'll hopefully see, is the CTA finally standing up and say, okay, guys, been dragging your feet for so long. Now, over and above the compensation, here's a fine of $10,000 or $15,000.
So,
hopefully we see that.
In your opinion, John, even based on this ruling today, which, as I said, is good news any way you slice it for consumers who've run into problems like these with cancels or delays or whatever, is the recommendation still, because we all know how long the backlog is here, we've talked about that before, is the recommendation still go to small claims court? That's your best shot?
Yep, still there. A year and a half to go through a CTA. So if you want your money faster, and now, the argument that, the judges will be using in those small claims court will be backed by a judgment of the Supreme Court of Canada.
Okay. Well, there you go. At least there's something. John, thanks so much. Appreciate it.
All right, sir. Have a good one.
You take care. John Gradek, aviation management professor over at McGill. So look, the good news, maybe. That's why I always say, in theory, it's good news. In practice, there's 30,000 people waiting on a list. This means, okay, what? If yours is judged to be, payable, they won't appeal. But his recommendation is still, you want to get your money, and especially if it's, a lot of money, go to small claims court. You have a better shot there against the airlines than you do going through the Canadian Transportation Agency. Sad but true.